turn off this WebEx here. All right. All right. Do we have the? Okay. The court is on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. Ms. Rodriguez appears today with counsels Ms. Trujillo and Ms. Devereaux. Mr. Praley and Mr. McCormick appear today for the state. We are outside of the presence of the jury who is in deliberations, and we have received a question from the jury. It appears they wish to watch what they describe as or asking if the first 45 minutes of the proffer video is available to watch. I don't believe, Mr. Perelia, that the state introduced the proffer video. Is that correct?
Not in its entirety like they're asking. There were 3 clips that were brought in. If the court remembers, the first was dealing with, it was the interview room, and it was the discussion of a reference to gang. The next portion was the body-worn cam of Detective Burrows regarding the use of the word gang. And then the final clip would have been Hosanna Varela detailing the sequence of events leading up to the murder with the beer bottles. So those would be the 3 clips, but no, the court is correct. There's not the proffer in its entirety, as there wouldn't have been a foundation to admit that at that point.
Can I ask, the clips that were played, were they in the first 45 minutes of that conversation, or did they come from different portions of that video?
I believe different portions. I would have to check those timestamps, but I believe
they're not.
They're, from the defense perspective, they're not from that first 45 minutes? Okay.
The first, I think what they're talking about is the narration portion. What we've described as Hosanna being just narrating. None of that information came out during that.
Okay. But you're confident from your, I guess your position is that neither of those clips are from that first 45
I
minutes.
am very confident off the top of my head. Of course, double check me, Mr. Prelia. My computer says it's working on updates, and I'm only 30% complete, so I can't pull anything up on my computer right now, which is not very helpful. But I am like 90%, 99% sure, because each of those clips came as a result of a question-answer interaction between Hosanna and Mr. Burrows. And that initial 45 minutes, there was no question answers. It was just, as he's described, narration, letting her talk.
All right. Ms. Devereaux, can you then give me the defendant's position on the juror question?
I would ask the court to respond something along the lines of the proffer video is not in evidence. You have all the information, or you can only review the evidence that has been submitted in this case.
All right, thank you. Mr. Perelia, Mr. McCormick, can you give me the state's position on the response?
It's 100%.
Judge, we would concur with counsel. I think that's an appropriate response.
All right. And Ms. Devereaux, can you repeat your proposed response?
Sure. The proffer video was not entered into evidence in this case. You may only consider evidence that has been entered, or something like that.
Or I guess the proffer video in its entirety has not been admitted, because obviously parts have been admitted.
I mean, you could also just say
Can you repeat the second sentence, Ms. Devereaux? You may only consider, and I can't remember the
you
phrase.
may only consider evidence that has been submitted and accepted into evidence, or by the court, or something along those lines. Sorry, it's not very, yeah, you can only consider the evidence that has been submitted. That's a much better way of putting it. Thank you.
But to Mr. Prelia's point, I think maybe add in that part two, that in its entirety, because they still have some clips.
Let me read you this proposal to see if it's acceptable to both parties. So this is how I phrased it. The requested portion of the proffer video was not entered into evidence in this case. You may only consider the evidence presented at trial in making your determinations.
No objection.
Ms. Devereaux, you're fine with that?
Yes, thank you.
And from the state, are you fine with that?
I appreciate the clarification. I'm fine with that.
Okay, all right. Then I will provide that written response to the jury, and then we will call you all back if there's additional questions or any other communication.
Thank you, Judge.
Thank you. What's that? No, they,
Do you want us to wait until they ask?
yeah, wait till they ask. And let's worry about problems. Okay, that sounds good. You have the, so keep this, give them that in response to that question. Let me label them. Hey, how's that? Listen.
It was good.
How's that?
Okay, did you write it down?
Oh, you have another question?
Okay, I'll be right there, okay? Okay, bye.
Deputies, they got another question. Go on. Back. Sorry.
Oh, no, he's not answering.
So hopefully they can catch it.
If there's anybody by West Security,
Your call has been forwarded to
You
voicemail.
can give them that answer when you pick up the other question.
At the tone, please record your message. When you have finished recording, you may hang up.
No luck?
They're here.
Oh, they're here, okay.
We have another question. Come back.
Hey, you wanna make it quick?
Hang on, Alyssa. Run, Bruce, run.
You didn't get very far, did you? Did they even get the answer? Was it even enough time to print that and bring it back? That's how I'm like,
All
I don't think.
lifting, I mean, need some cardio.
I mean, I went to the gym this morning still.
God, what does that say?
I don't even remember what those
Oh,
are.
3D and 3E, okay.
Yes. What are those? It's a C. I told them.
I thought those were numbers.
Which house is it though? I don't remember. I think it's a 20.
Do you have Mac's cell phone?
No. I called Nikki and I just texted him.
Anyways,
Do you have Jessica's cell phone? Maybe Jessica can.
I don't know.
I just got one. That's why I was like, this is not something I need to know.
Okay, let's see. other questions? Yeah, yeah, I'll do that. Thank you. Good luck. Like every time we have a moving groups, we'll have to keep coming back.
Oh, we should have asked them to bring over the clean laptop. Or who can, oh, so you have to use yours.
So what I did when I was in that security trial, I just used my airplane map, I used your DVD.
And I figured out, okay.
I don't know how long those videos are, so you can do it in the courtroom, or I can just go to the jury rooms with them. Or we
It probably makes sense if we can move the TV in there to just move the TV in there.
let me see if Josh is here.
Is there like a plug by the sink?
Yes, I can
Yes.
get it.
Yeah,
set up.
there's several there, so.
I'm just gonna ask Josh because. Not my actual one.
Yeah, that's probably.
Go through our.
All right, are we back? We're back on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. The parties are present as previously captioned. The jurors contacted us with another question just as the parties had left the courtroom. It appears the question is that they want to watch videos. It's a little hard to read. I believe those are videos 3D and 3E. Ms. Devereaux, Ms. Trujillo, do you believe I'm reading that correctly?
Yes. Yeah.
Okay. And Mr. Praley and Mr. McCormick, do you agree that that's accurate?
Yes.
Okay, all right. Mr. Praley, remind me, I believe those videos are in the nature of surveillance footage, is that correct?
That's correct.
Okay. Ms. Devereaux, Mr. Trujillo, any record that the defense needs to make regarding this inquiry?
No, Your Honor, I think these are fine. I guess the only thing is if the prosecution has a disk or, I don't know, however, like write a computer, I'm not sure if this can be unfettered access for them. I don't believe it's testimonial.
Yes, and so, Mr. Hill, I appreciate you bringing that up. That is my understanding that it's not testimonial, so I believe that they would have unfeathered access to it unless either of the parties disagree with that, but that's my initial impression. Mr. Praley, can I ask you, I do have some cases on this morning, but I imagine those are fairly brief. Is it reasonable to request, can we slide your TV into the jury room for the jurors' use for these two video exhibits?
Yes.
I don't want to do that without your permission, since it belongs to the DA's office.
No, that's fine if the court wants to do that. I just need to get the trial laptop, and then they would have to, or the
So-
Bailiffs would have to operate.
So we were just speaking with that. We have a laptop that we can utilize. And I am going to have one of my staff in there operating the laptop at the jury's discretion, just so they don't go onto the laptop for some other unrelated purpose. From the defense, do you have any objection to that procedure?
No, that was just our concern. It's like the logistics.
Yeah, my staff will be there in there to supervise. And Mr. Praley, Mr. McCormick, do you have any objection to that procedure?
No.
All right. And do we have those discs, 3D and 3E? Okay, all right. All right, then what we'll do, that will be the process. We will slide the TV that is on the cart there into the jury room for their use. My staff will take our equipment into the jury room and assist them with playing the video. Mr. Praley, can you give me a rough estimate? I don't remember them being especially lengthy.
They're,
One is they're both about 5 minutes.
Both about 5 minutes. So they will have the ability to stop, rewind, and watch them again.
But I think we can do
I would prefer that you do it in the jury room, just so that we can get going on that when they come in. So we'll do that in the jury room, and my staff will be there to assist. All right, then we will get a hold of you all if there's another question or any other communications from the jury.
Thank you.
Mr. Praley, is there anything special Alyssa needs to know about that TV? Is it?
the only thing I think that we need to address is that the HDMI cord is underneath this strip, so we're gonna need to take that up in order to disconnect it.
Do we have another one? Do you know? Like a spare? Do we have an HDMI cord?
Otherwise, I can try and go back and get a different one, Joe. I mean, I think we're done in here.
If that's not a big deal, then we can do that. Alyssa, will you just get with Mickey and make sure that you know? Let me get my DVD player.
Thanks for your
Because we have to stretch it across the table. Your remote will be here.
I'm sorry.
I was talking to.
Why don't you reach out and see if there's somebody that can cover them last minute? I don't know if anybody's around. Also, reach out to Judge Esser. That's a possibility. Okay. Mr. Praley, is Mr. Dickerson's family now present?
They are.
All right. The court will go on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. Ms. Rodriguez appears today with counsel Ms. Devereaux and Ms. Trujillo. Mr. Praley and Mr. McCormick appear today for the state. It is the court's understanding that the victim representatives are present in court as well. The court has received word that the jury has reached a verdict in this matter. We will call the jury in and receive the verdict. If you'll bring the jury in, please.
Judge, are you okay with Ms. Rodriguez sitting for the verdict?
Yes, I am. Yes, I
Thank
am.
you.
She can remain seated and understand her preference.
Thank you. Okay.
Okay. Will you just communicate with them and get it set up? All right, thank you. And will you let her know about those misdemeanor dates?
Please rise for the jury.
All right, thank you. Please be seated. Ladies and gentlemen of the jury, who among you has been selected as foreperson of the jury? Juror number one. Juror number one, I have been informed that the jury has reached a verdict in this case. Is that correct?
Yes.
All right, thank you. Ma'am, if you'll please provide the verdict forms to my bailiff. All right, and Madam Foreperson, it appears that the jury verdict forms for count 5 and count 4 are incomplete. What I'm going to do, I'm going to provide those verdict forms back to the jury and ask the jury to retire just to ensure there wasn't any typographical errors, but it appears that the first 2 forms in this packet have not been completed by the jury. I'm going to have my staff bring that back to you. Yes, and please rise while the jury retires, and then as soon as those forms are complete, we'll bring the jury back up. I'm sorry. I am not. All right, thank you. Please be seated. And if the parties will remain, it appears they were just partially incomplete, so I anticipate they'll be able to rectify that quickly. And Alyssa, as soon as they've indicated to you that they're complete, you can bring them back out.
Okay.
Okay.
Please rise for the jury.
All right, thank you. Please rise.
Who's handling AWARS? Mr. Michael, who's handling AWARS? Is it Miss Akers?
Ms. Akers.
Okay. Do you know what she was gonna do? Sorry, she's gonna do a
All right, thank you. Please be seated. Madam Foreperson, was the jury able to complete the incomplete forms?
Yes.
All right, thank you. If you'll please provide those to my bailiff. All right, thank you. Ms. Rodriguez, the verdict of the jury reads as follows, dispensing with the caption, jury verdict count 1, murder in the first degree. We, the jury, find the defendant Stacy Marie Rodriguez guilty of murder in the first degree, signed by the foreperson. Jury verdict count 2, first degree arson. We, the jury, find the defendant Stacy Marie Rodriguez guilty of first degree arson, signed by the foreperson. Jury verdict count 3, tampering with a deceased human body. We, the jury, find the defendant Stacy Marie Rodriguez guilty of tampering with a deceased body, signed by the foreperson. And then, I'm sorry, to go back to count 2, jury verdict count 2, first degree arson, verdict question form. We further find with respect to the verdict question for this count as follows. Did the prosecution prove beyond a reasonable doubt that the arson was of an occupied structure? The jury has marked yes, and that is signed by the foreperson. Jury verdict count 4, excuse me. second-degree burglary, arson. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of second-degree burglary, arson, and that verdict is signed by the foreperson. Jury verdict, count 4, burglary, arson, verdict question form. We further find with respect to the verdict question for this count as follows. Did the prosecution prove beyond a reasonable doubt that the structure burglarized by the defendant was a dwelling? The jury has selected yes, and that is signed by the foreperson. And then finally, jury verdict, count 5, second-degree burglary, theft. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of second-degree burglary, theft. That verdict is signed by the foreperson. Jury verdict for count 5, burglary, theft, verdict question form. We further find with respect to the verdict question for this count as follows. Did the prosecution prove beyond a reasonable doubt that the structure burglarized by the defendant was a dwelling? The jury has selected yes, and that verdict form is signed by the foreperson. Madam Foreperson, is this the verdict of the jury?
Yes.
All right, thank you. Does either side wish to have the jury polled?
Yes, please.
All right, thank you. Juror number 1, is this your verdict and the verdict of the juries? Yes. And juror number 2, is this your verdict and the verdict of the jury?
Yes.
Juror number 3, is this your verdict and the verdict of the jury?
Yes.
Juror number 4, is this your verdict and the verdict of the jury?
Yes.
Juror number 5, is this your verdict and the verdict of the jury?
Yes.
Juror number 6, is this your verdict and the verdict of the jury?
Yes.
Juror number 7, is this your verdict and the verdict of the jury?
Yes.
Juror number 9, is this your verdict and the verdict of the jury?
Yes.
Juror number 10, is this your verdict and the verdict of the jury?
Yes.
Juror number 12, is this your verdict and the verdict of the jury?
Yes.
Juror number 13, is this your verdict and the verdict of the jury? Juror number 14, is this your verdict and the verdict of the jury?
Yes.
All right, thank you. Judgments of guilty are now entered in this matter as to counts 1 through 5, and we will address setting the matter for sentencing in just a moment. Ladies and gentlemen of the jury, you have now completed your duties as jurors in this case and are discharged with the thanks of the court. The question may arise whether you may discuss this case with the lawyers, defendants, or other persons. For your guidance, the court instructs you that whether you talk to anyone is entirely your own decision. It is proper for others to discuss the case with you, and you may talk with them, but you need not. If you talk to them, you may tell them as much or as little as you like about your deliberations or the facts that influenced your decision. If any person persists in discussing the case over your objection or becomes critical of your service, either before or after any discussion has begun, please report it to me at once. And ladies and gentlemen, I want to add my own personal comments. I know that jury duty is not something that people often looking forward to, and it's something that people often look to actively avoid. But it is my experience when someone has been selected to be on a jury and they go through this process, even if it was a difficult and long experience for them, they at least come away with some positive view of our justice system and the important work that we do here in the 19th Judicial District. I genuinely hope that was your experience with your service in this trial. With that, you are released. I would also like to go back to the jury room and give you my own personal thanks, as well as I have some certificates regarding your jury service to give to you. Now, I know it's been a very, very long 2.5 weeks, so if you all would like to get out of here, please do. It's not going to hurt my feelings if you decide to go on, but for those of you who would like to wait, I should be back in the jury room in just a few minutes. All right, thank you again for your service, and with that, you are discharged. Please rise for the jury. All right, thank you. Please be seated. All right, judgments as to counts 1 through 5 will now enter. Judgment as to count 1 by statute dictates that the court should take every effort to proceed to sentencing as soon as possible. The court's intending on setting this matter out for sentencing at 3 p.m. Mr. McCormick and Mr. Perelia, can you make that work?
Yes,
And it looks like that does work for Mr. Dickerson and his family?
correct.
Your Honor, I cannot do that. I'm sorry.
All right. Can you do 2:30?
Your Honor, Ms. Rodriguez is requesting, her brothers aren't here, they are at work. I know the court's preference is to do it as soon as possible, but if it's possible to do another day, that's what our request is.
All right, I appreciate that that's the defendant's request. However, I do need to, by statute, proceed to sentencing quickly in this matter. So I am going to set sentencing to 3 p.m. today.
I'm sorry, so there was two different issues.
Sure.
I have a personal issue, so if we could do it sooner this afternoon, I'd appreciate it.
Can we do 2:30?
If we can do 2 o'clock, that'd even be better.
Judge Esther said she could do her 2 o'clock.
Let's do 2:15. I think that might be the best I could do. I will need to make some other arrangements with my docket this afternoon. But we'll reconvene for sentencing at 2:15. Mr. Pralia, Mr. McCormick, does that also work for the victim representative?
Yes.
Okay. All right, then we'll be in recess in this matter until 2:15.
Thank you.
All right, thank you. Yeah, I assume you're going
They're not going. So what's easier? So, yeah, we should be able to, I think Judge Esther might be able to do the 2 o'clock, I don't know. I gotta check the judge. He's, yeah, but the hearings are not going. Okay. So if we have to, we can interrupt our sentencing call. Let me check with him and I'll let you know. Okay.
Mr. Pirelli and Mr. McCormick, can you tell me, did the victim representatives intend to be here in person?
Yes, let me just make sure. They're here.
Okay. All right, will you put us on FTR, please? And Mr. Pirelli, are you ready to proceed?
We are.
All right, thank you. We are back on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. The parties are present as previously captioned. We come on for sentencing after the verdicts of the jury. Mr. Pirelli, before you begin your sentencing argument, are there any statements that the state wishes to present for the court's consideration?
Yes, Your Honor.
All right, why don't you go ahead and proceed prior to your sentencing argument?
Mr. Alan Dickerson wishes to make a statement.
All right, thank you. Mr. Dickerson, will you please come to the podium, sir? And Mr. Dickerson, before you again, will you please state your full name and spell your last name for the record? And then I'm happy to consider anything that you'd like to tell me.
My name is Alan Charles Dickerson, Dickerson. I'm Christopher's father, and this time I would like to set the record straight about Christopher and the character of that young man. Christopher was a loving and giving child. He overcame many difficulties growing up. When he was 10, he had a bad accident on a bike and broke both wrists. He overcame that and was able to purchase a dirt bike and continue to enjoy the outdoors, riding dirt bikes with his friends. He was always interested in tinkering with things. He was a kind and generous young man. He was friendly to all he met. He was an extrovert in nature. He never saw anything bad in the people that he met, although he was able to overlook other people's troubles and be giving and generous. One time when he was going to school in Laramie, Wyoming, we were buying a meal for Chris, and he purchased a meal for someone that was having extreme difficulty that most of us would just overlook, but not Chris, because his character was giving and generous. He bought that man a meal. He saw him in need. Chris achieved his dream of getting a higher education. He graduated Wildtech in Laramie, Wyoming with a degree in diesel mechanics and a bachelor's degree, an associate degree in business administration. Christopher got his first break when he interviewed for Noosa Yogurt. He was a shift manager for Noosa Yogurt, and I'd like to set the record straight. Chris did have difficulty at Noosa at the last 30 days because he was a whistleblower. Chris was a stand-up individual, and when Noosa was going through a buyout from Sosa Brands, He would not go along with management, even at the risk of losing his job. Chris stood up for a contractor that was a snow removal contractor for them, and he eventually lost his job because of that retaliation. He was a whistleblower. Chris did not deserve to die that day when he befriended those two young women. Chris deserved so much more in his life. He had overcome so much more in his life. He overcame more than most people would be able to accomplish. I was very proud of him. He had his difficulties as a young man. He suffered addictions. He overcame them. And as he was growing and learning about how to become a better man, to help himself achieve a better life, he was able to accomplish his dreams. He bought a home. He saved. He lived with us for at least 3 years while he was saving for a home. He had a serious relationship with a young woman, and it didn't work out. That was a hardship for him. But he had a loving companion in his dog, Juna, and he adored her, and she adored him. We now have Juna, and it's the only thing we have left of Christopher to remember him by. All his earthly possessions were consumed in a fire meant to conceal a horrible death inflicted on him by two individuals. Again, Chris did not deserve the outcome that he received. He did not deserve to have his body mutilated, moved, tampered with. He did not deserve to leave nothing for his family and friends to remember him by. All his childhood mementos gone. I ask this court to do justice today for Christopher and his family and his friends and the community at large that were put at risk by the arson to conceal a horrible death of a loving, giving young man. I ask for the maximum sentence allowed by law. This person has victimized us again over this last 2.5 weeks by dragging us through a painful accounting that is totally based in fiction. I ask for the jury to not let this person hurt or harm any other person or family. That's what I have to say.
All right, thank you, Mr. Dickerson. I appreciate your presence throughout this process. Mr. Pralia, does the state have any additional witness statements for the court's consideration?
Yes.
All right, thank you.
Hi,
Thank you.
my name is Ann Dickerson, and I'm Christopher's mother.
And ma'am, I'm so sorry. Can you speak up just a little bit? I think I heard you say that you were Ann Dickerson and that you were Christopher's mother. Is that correct?
Yes.
All right, thank you.
Yes. Thank you all for your time. Thank you for this chance to talk about Christopher. It is so good to hear people saying his name and speaking of him well. When we lost Chris, I didn't feel that I could bear it, that things could go on. He was our firstborn. He was his brother's only sibling. He was blessed with a good sense of humor, an adventurous kind of curiosity, and good nature and generosity. He did struggle. He did struggle, and But he didn't give up, and there were people who helped him not give up. And I want to thank them, including his brother Matthew, my family, Ellen's family, our friends, his teachers, his counselors, the people that he ran into in the courts, in the system, in his friends. He just never gave up trying to make it better for all of us. I just want to thank you. We have been so fortunate to have a team of people that are shielding and protecting Christopher when we can't and when he can't. I am just so grateful. I can't tell you how grateful I am that his name was spoken and spoken of well. Thank you.
All right, thank you, Ms. Dickerson. I appreciate you being here today. Mr. Prelia, does the state have any other witness statements that they wish to present?
No, Your Honor.
All right, thank you. From the state, any sentencing argument, please go ahead.
Justice delayed is not justice denied. This court has seen this family in this courtroom at nearly every appearance since this occurred. As of today, that is 1,257 days. 3 years, 5 months, and 10 days of them coming to court and hearing about this horrific death. And I can't imagine what that's like for a family. I can't imagine what that's like as a parent to have what has happened to them from the very outset. That on October 3rd, that the Weld County coroner comes to your door asking where your son goes to the dentist so they can help identify a body that was found in his house. And there needs to be some recognition of how we get to where we're at today. And the first person that deserves recognition is Detective Jerry Burrows. Because after that tragedy struck, he sacrificed his own family and everything else in order to provide this closure today for that family. Without sleeping, to investigate, to come up with who did these horrific crimes. And it morphed from simply an arson to a first-degree murder the minute that autopsy took place. And he did everything for them, and he should be applauded for that, along with other members of the Greeley Police Department and their investigative work. And that was all because these two individuals did nothing to help, did nothing to care about Chris, the person, who he was, or anything about him, or anything about him. They cared about themselves. And then I would submit you've watched it on November 11th, based on all of that hard investigative work. You saw the arrests on the body-worn camera, and it was obvious right then, to me and anyone else in law enforcement or the jury, who did what. I can say personally, I never doubted once who took Chris's life. In large part, that's why we agreed to a proffer with Hosanna Varela. There was never a doubt that this defendant took his life because of her violent and antisocial character, her behavior. And candidly, Judge, I never entertained any possibility of a plea in this case. And the reasoning was simple, that I couldn't have any confidence that she would not kill again and put another victim's family in the position that the Dickersons are today. I don't know what the court's been able to view or not. I know you have a very difficult job during trial. But this entire process has seemed like a game to her. She jokes, she laughs, she demeans the victim in the very setting where she stabbed him, and she's going through a trial for it. Her true character and true actions throughout this process, throughout this case, throughout her notes, are diabolical and despicable. She is a threat to society, and there is no place for her in it. For the Dickersons, I hope this verdict brings some peace, maybe some closure in this journey, provides some help with the grief, hopefully some healing. I just want to say I appreciate their constant motivational factors for us and this team, which should include Lily Parker, who worked countless hours on this case as well from my office. And them just coming gave us the strength to keep going in these 3.5 years. I'm asking the court to provide the only sentence that you can as to murder in the first degree, life without the possibility of parole, with consecutive sentences on each of the other counts that this jury found. They saw her true character. They saw her true actions. Your sentence should reflect that. Thank you.
All right, thank you. Ms. Devereaux, Ms. Trujillo, prior to any sentencing argument, does the defense have any witness statements they wish to present to the court?
No, and we're not making any statements at this time.
All right, thank you. And Ms. Devereaux, I assume the answer is the same for Ms. Rodriguez, but for the record, I'm just going to inquire with her briefly. Do you need a moment to speak with her before I do?
A moment, thank you.
All right, thank you. Ms. Rodriguez, is there anything that you would like to tell me before I impose sentence in this case? You certainly don't have to if you don't want to.
No, thank you.
All right, thank you. All right. Ms. Rodriguez, as to count one, the only sentence that the law provides for is life in prison without the possibility of parole. Under the circumstances of this case, that is the only sentence the court legally can provide. It's also the only sentence the court can provide if there is to be any sense of justice out of these proceedings. Ms. Rodriguez, your actions were horrible. Your decisions were horrible, both in the commission of this act and the choices that you made after this act. It is a struggle for this court to understand how you can go from meeting a person to viciously stabbing them in the neck until they are dead in the course of a few hours. It's one of the most disturbing cases that I think has been before this court since I've had this job. Because everything that I've heard about Mr. Dickerson indicates that he is blameless in this whole scenario. The man that I saw on the surveillance video in downtown Greeley didn't appear to me to be a creepy man, a disturbed man, a dangerous man. If anything, he seemed to me to be a slightly lonely man, just at the bars, attempting to make some contact with other people that evening. One of the hardest things about my job is that I am forced to meet wonderful and caring parents like Mr. and Ms. Dickerson in the back of the courtroom under just the most tragic circumstances that they've unfortunately had to go through in their lives. It is the loss of a life under any circumstances and tragic, but when parents have to bury a child, even if that child is grown, Mr. Dickerson and Ms. Dickerson, I can't even imagine the pain that you have gone through. And I wanted to say to both of you, I very much appreciate the respectful way that you have carried yourself throughout the course of these years as this case has progressed. I don't know that very many people would have the capacity to carry themselves in such a respectful way under such horrible circumstances, but I am very much appreciative for the participation that you've shown throughout this process and your willingness to be here every day to ensure that your son's memory is not forgotten by anyone and that your loss is not forgotten by anyone. Ms. Rodriguez, there's nothing that I can say about this act that in any way paints it in any sort of justifiable or excusable light. There's no context to this matter that makes it less horrible. So as I've stated, the sentence in this matter is just, it is deserved, it is necessary, and it is appropriate under these circumstances. Ms. Rodriguez, what I need you to consider is what you do tomorrow, what you do a year from now, and what you do 10 years from now, and what you do the rest of your life. Ms. Rodriguez, you're going to spend the rest of your natural life in the Department of Corrections, but you will still be alive. And Ms. Rodriguez, you're very young. I would imagine that the person that you are 10 years from now, 20 years from now, 30 years from now, probably has a very different perspective on the actions that caused you to be before the court today. As you spend the rest of your life in the Department of Corrections, I imagine that you're going to have interactions with many young women coming into prison, women who are lost, women who are broken, women who are scared. You're going to have to make a decision if you're going to have any meaning in your life going forward on who the person you want to be to those people you interact with. You will have an opportunity to take these hard lessons and perhaps convey some knowledge and perhaps present some comfort to the many people that I imagine that you'll interact with over the years. And you're going to have an influence on them, and that influence is either going to be positive or negative. If you're going to find any peace with your existence going forward, I hope that you give that some consideration. I hope you consider what you can do in the time that you have in the environment that you'll be in to have some sort of positive impact in this world. You will never be able to make it up to the Dickersons for the harm that you caused their son. But with time, you might be able to demonstrate to them that you should not be completely and totally defined by the most horrible choice that you've ever made in your life. I don't know what you are going to do from this point forward, but I hope that whatever your choices are going forward, that they are thoughtful choices, they're considerate choices, and I hope that you find some peace in the rest of your existence. With that, the court, regarding the charges for which the jury has reached a verdict, is going to issue the following sentence. As to count 1, Murder in the first degree, the court will sentence you to serve the rest of your natural life in prison without the possibility of parole. With respect to count 2, first-degree arson, the court is going to sentence you to 32 years in the Department of Corrections. That sentence will run consecutively with count 1. With respect to count 3, tampering with a deceased human body, the court is going to sentence you to 12 years in the Department of Corrections. That count will run consecutively with the other counts. As to counts 4 and 5, the court on each count is going to sentence you to 12 years in the Department of Corrections. Counts 4 and 5 will run concurrently with each other, but consecutively with counts 1, 2, and 3. Ms. Devereaux, the state had mentioned indication of pre-sentence confinement of 1,257 days. Do you believe that is accurate? All right. The court will note for the record that you have been in custody 1,257 days in this matter. Mr. Varela, Mr. McCormick, I don't think you mentioned it in your sentencing argument, but does the state wish to make any record regarding restitution?
But we do, Judge. In this particular case, we're requesting $2,505.21 payable to the Crime Victims Compensation. We're asking for $286,527.34 to Farmers Insurance.
And let me make sure I have that last number, $286,527 and
34 cents.
34 cents.
So that total would be $286,000 or $286,032.55.
I'm sorry, Mr. McCormick.
I know.
I want to make sure that I have this correctly because I think I heard two different amounts. So the first amount that I heard was $2,505.21. That is payable to Crime Victim Compensation.
Correct.
And then the second payee was to Farmers Insurance. Was there only two payees?
Just those two.
And then can you repeat the amount for the Farmers Insurance? Because I think
yes, that was 286,527.34.
34, okay.
So the grand total would be 286,032.55.
Oh, I'm sorry. I think that may have been where I misunderstood you. Okay.
And we're asking that that be joint and several with the co-defendant in this case, Hosanna Varela, and that case number is 21CR2250.
2250. And Mr. McCormick, will the state be able to follow up with a written motion today?
I believe it's in the process and will be filed shortly.
All right, thank you. Ms. Devereaux, what I am going to do, I am going to conditionally order that restitution amount pending any request for a hearing by the defendant. I'll give you 30 days to file any request for a hearing if you choose to do so. It will be a condition of this sentence, Ms. Rodriguez, that you be liable for the payment of restitution in the amount of $2,505.21 payable to the Crime Victim Compensation Board and liable for restitution in the amount of $286,527.34 payable to Farmers Insurance. And I will review the motion filed by the state once that is provided to the court. Ms. Rodriguez, given your sentence, I do find that you are currently indigent and lack the current financial ability to pay some of these fees. I am going to waive any waivable costs and fees that are associated with this case. You will remain liable for any mandatory fees that I must impose, as well as the restitution judgment that I've entered today, pending any future hearings on the matter. Ms. Rodriguez, for what it's worth, I genuinely hope that you do find some peace in your existence after you leave this courtroom. I don't expect that it will happen tomorrow, and it may not happen a year from now or 10 years from now. But just as Mr. Dickerson deserved to live a life unmolested by this sort of pain and agony and hurt, we all deserve to live a life where we have some peace and some type of fulfillment in our existence. So I hope you consider that in the choices that you make after you leave this courtroom. With that, that will be the decision of the court. Mr. Pralia, is there any other record the state needs to make today?
Judge, we also will be filing a cost of prosecution. We just need to get those numbers together as well.
All right. And Ms. Devereaux, for the purposes of any future appeal, I will find that the defendant is indigent and lacking funds to pay for either counsel or any transcripts on appeal. I just ask that you follow up with any written motions you believe are necessary to document that issue. Ms. Devereaux, is there any other record the defense needs to make today?
No.
All right. That will be the order of the court, and the court will be in recess until 3 p.m.
Have a good night.
Appreciate it. No, it's not. Thank you.
I know.
Not doing so bad, but. So,
Rest of, oh, that's it for your custody, it's not you anymore.
yeah, what we're doing here is 5 and 2/3, so I think that one you guys had. Everything was just back to normal, back in the picture,
Yes.
back to normal life.
3:30
As normal, yeah, it's
3:30 and 4 o'clock. 3:30 is in custody.
And for tomorrow.
No, today.
DOC, third DOC.
Oh, no, JK.
Don't
Just kidding.
do that to me. All right.
All right,
Yeah.
thank you so much.
Yep.